Did she let people in, Amy? Can you tell?
Yeah. Yeah.
All right. Good morning, everyone. We're going to wait about a minute to let additional folks join before we get started. All right. It's 9:01. You think we should start, Amy?
Sure.
All right. Good morning, everybody. This is Carlton Hilson. I'm joined this morning by Amy Wilkes, and welcome to the Burr Morning Show. This is going to be a short show, as I believe most everyone is aware. With the Federal Trade Commission's rule on non-competes, we've had a significant development this week, which we're going to talk about. We're going to talk about the impact of that. But we'll go ahead and get started. I want to let you guys know that if you have any questions at the end, Amy and I's email addresses are both linked in the invite to the Burr Morning Show. So please feel free to reach out to us by email or telephone. Amy, why don't you tell us about the Federal Trade Commission's non-compete ban?
Sure. So let's talk a little bit about where we were before Tuesday. Carlton will flip my slide for me. So back in January of 2023, the FTC issued their proposed rule, which is basically a blanket ban on non-competes. As you would expect, there was a lot of pushback from the business community on this, and they received a lot of comments. And then in April, they put out their final rule. And I think, one thing that was significant about that rule is that it was retroactive, which is pretty unusual in the law. So the rule was scheduled to go into effect September 4th of this year. And that was going to be, a pretty significant change in the law, pretty much an across the board ban on non-competes.
Yeah, and this was very broad too. The FTC speculated that 30 million Americans were subject or are subject to non-competes, and that comes out to about 18% of workers in America, according to their statistics at least. So there was, a very, very high number of working Americans that were going to be impacted by this proposed ban of non-competes. Now, the exceptions to the rule are very limited. There's really 4 of them. Again, this has a very broad scope and is intended to ban non-competes with most all workers. The only exceptions that existed are for one, senior executives. And, I anticipate if this ever goes into effect, there will be a lot of litigation as to what is a senior executive. But it's certainly somebody who makes at least $151,000 or more in annual compensation. The second exception was for non-compete agreements involving the sale of a business or some sort of franchise agreement. The third was for any actions that accrued prior to September 4th, 2024, which again was the effective date of this rule. And the fourth was if the employer had a good faith belief that the rule does not apply. And again, that's another area where I think we would see significant litigation and arguing over what that really means. But those were the only exceptions to the rule. And otherwise, if the rule had gone into effect, non-competes would be banned in virtually all other circumstances.
So one thing that was significant is that the rule was going to require employers to give notice to their employees who were bound by an existing non-compete that the non-compete would not be enforced against them in the future. And, I think that's really significant because, a lot of time with non-competes, they don't really get enforced. Part of the value of the non-compete is that it's there and the employee thinks you're going to enforce it, even if push came to shove, you actually wouldn't. So having to affirmatively tell all your employees, hey, we're not going to enforce this, that would really have an effect, I think. So, and they put out this model notice that, had some kind of interesting language in it, and everyone was going to have to send that out. So,
Yeah, and we've certainly been preparing clients to send this notice or a substantially similar one out if the rule was to go into effect. But at the same time, we've also been watching several federal court cases that have challenged the rule and challenged its implementation. There is a case in Florida, Texas, and Pennsylvania. All three of those cases have issued now preliminary rulings. The Florida decision blocked the rule, but only to the named plaintiffs. The Pennsylvania decision allowed the rule to go into effect or declined to grant an injunction against the rule. And then there's the Texas case, and that's the one where the court initially granted a preliminary injunction blocking the rule with respect to the named plaintiffs. But then after that ruling came out, the plaintiffs filed for summary judgment, and the judge in that case issued a summary judgment opinion on Tuesday that grants an injunction against the rule nationwide, which totally blocks the rule from going into effect nationwide. And so that's what the big news has been this week.
Yeah, so the court set aside the rule, and basically it was on two grounds. They said that the Federal Trade Commission did not have statutory authority to issue substantive rules. This non-compete rule was really kind of the first time the FTC has tried to flex its muscle and issue substantive rules. And the court said, no, the law doesn't, you don't have that authority under the statute. You can only issue procedural rules that govern enforcement actions. So that was one basis. The second is that the rule was arbitrary and capricious, and that's a standard in administrative law for court review of agency actions. And the reason the court said it was arbitrary and capricious, in a nutshell, is that it was too broad. Just an across-the-board, one-size-fits-all categorical ban. Just they didn't have a basis for that based on the evidence.
So, Amy, what do you think about the other two cases in Florida and Pennsylvania that are still out there? Do we see action in those?
Yeah, so we're still waiting summary judgment on those. It remains to be seen what those courts are going to do. But I think it's interesting. The FTC has not yet said whether or not they're going to appeal the Texas court's decision to set aside the rule. The Fifth Circuit, probably not the most friendly jurisdiction for an appeal. Yeah. The 11th Circuit for Florida, probably not either, but it's setting up a situation where the FTC might be waiting to see what happens. And, maybe the Pennsylvania case where they've gotten a favorable ruling so far. And you're looking at maybe a situation where there's a circuit split between the 5th, the 3rd, and the 11th. And I think, all lawyers know what happens when there's a circuit split sometimes. That puts you squarely in the Supreme Court. Right. Which, this year has been, or at least in past years, hostile to kind of nationwide injunctions and nationwide bans. Yeah. So that would be an interesting case.
Yeah, we certainly don't know what would happen if it goes to the Supreme Court, but I think we can say that based on recent precedent, the Supreme Court might not be friendly to the FTC's nationwide ban. And I do agree with you that an appeal to the Texas decision to the Fifth Circuit might not be the FTC's best decision, but that's certainly something that their attorneys are mulling over. So what does this mean? It means that employers, at least for now, do not have to worry about this proposed rule. It will not go into effect on September 4th, and we do not need to send out the notices to employees who have non-competes, as we discussed earlier. But let's keep in mind that we still have non-compete laws and rules in at least 47 states. And I think this serves as a good reminder in time for all employers to review their non-compete agreements and similar agreements as well, such as non-solicitation agreements and confidentiality agreements. I think we're going to continue to see increased scrutiny of those type of agreements by the courts. and maybe our federal agencies. So, you know, it's a good time to review those.
Yeah, I think we might also see some state action. You know, she said 47 states already have laws, but you know, given that it's been struck down, depending on, you know, the state legislatures and, you know, kind of priorities, we could see some state action. And, you know, depending on the election, we could see, you know, maybe some action in Congress.
Right.
And the FTC has said that they will continue, you know, case by case enforcement actions.
All right, so that's it. That is our update and our Burr Morning Show for today. Again, if you have questions, please feel free to reach out to me or Amy by email or telephone. I think both of us will be around the rest of the day. Thank you, everybody, and have a great weekend.
Thanks, guys.